In particular, there's one section of the majority opinion that says this opinion should not be read as supporting prior Federal Circuit opinions. And as the one example that it gives, it provides State Street as one opinion that it should not be read as supporting. So I would be concerned about using the useful, concrete, and tangible result test, just because I don't think that the courts are going to be looking to that as good law. They haven't specifically overruled it, but there are a number of indicators saying that it's not particularly in favor.
Well, if useful, concrete is abstract, arguably, then what would you add to the State Street test if you were God and you could make whatever you wanted to do happen? How would you define the State Street test to define what is abstract and what is patent eligible? Do you have any thoughts on how the Federal Circuit should maybe modify their State Street test to come up with an additional test beyond their current test? Because in effect, the Federal Circuit now is faced with either deciding abstract on an ad hoc basis, case by case, or trying to formulate a new test that would be in addition to their existing test.
Yeah, I don't envy the Federal Circuit its job in having to come up with that sort of test. Perhaps one test could be, as we mentioned before, the mental processes. Can this claim be performed solely in the human mind? And if so, that's leading us down a dangerous road. That's one option. Do you have any suggestions?
Well, it seems to me that, with emerging technologies being what they are, that the Federal Circuit is going to have several tests, because this case clearly, in my mind, cannot be compartmentalized to methods of doing business. And for example, I think it's going to be a very important decision with regard to software-based inventions and also medical diagnostic inventions, to name two important areas. And I don't think that they've cabined off those two technologies as effectively as the Supreme Court seemed to try to do. The other point that I wanted to make is that a lot of times, in my opinion, the tests are formulated much earlier in the process. In other words, the examiners, through their actual decision-making, and then those cases that get brought on appeal to the Board of Appeals of Patent, the BPAI. The BPAI hears hundreds and hundreds, thousands of cases a year, and they have precedential decisions, for example, that they hand down on areas like 101. So it seems to me that the real battleground in coming up with tests could ultimately be at the BPAI, because most of the BPAI decisions are not appealed to the Federal Circuit, unlike a lot of district court decisions which are. So in a way, the Federal Circuit is not going to have access to ruling on those decisions the way from the BPAI as they would infringement decisions involving issued patents from the district court. So do you think that as a patent attorney practicing before the Patent Office a fair amount, do you think that your clients are going to want to, in effect, create these tests with their particular application? Or do you think that most applicants are just going to effectively give up and the Patent Office will be able to write whatever tests they want through the mechanism of the few appeals that are actually fought out at the BPAI? I mean, how do you think, as a practical matter, these new tests are going to come about?
Certainly, as a practical matter, they're only going to come when specific cases are up through the chain. If cases can be dealt with at the examiner level, or if a client decides, we're not going to pursue this case anymore, we're not going to put forth the time and energy that it takes, we're just going to call it quits with this particular case and focus our resources elsewhere, then that will never come up for decision. It's only going to be those cases that applicants are willing to put their resources behind to get up to the levels of the BPAI and the Federal Circuit where these new tests can be developed.
And what's surprising to me is the few number of cases that actually get appealed from the BPAI to the Federal Circuit. It's a very small number every year, and it's been flat over the last decade. Whereas the number of cases that are being appealed from the examiners to the BPAI is going straight up. So one wonders whether the most important cases, particularly the ones that the board designates as precedential, will ever really get reviewed by the Federal Circuit as the highest authority that the Supreme Court has charged with coming up with these new tests. The other point that I wanted to ask you about is this. Under patent prosecution rules, claims are interpreted according to the broadest reasonable construction standard, and that means that claims will be viewed very broadly in the examination process, whereas in an issued patent in patent litigation in the district court or in the ITC, you have Markman rulings and the claims tend to be more narrow. In other words, as a practical matter, do you think there's going to be more 101 issues at the examination level than at the patent enforcement level, because the claims in effect are going to be more narrowly interpreted when they're in the federal courts?
So I need to answer that question in part, because I think there's, as we move down the road, there's going to be different things that happen. Initially, I think there probably will be a number of cases in litigation that are attacked on 101 grounds, especially those cases that were issued from the Patent Office before 101 became a really big deal, before the machine or transformation test was really used often by the Patent Office and really promoted by the courts. For those older cases, certainly I think there's going to be a lot of attacking 101 issues, sort of as we've seen with the machine or transformation test recently. Over time, I would hope that would decrease a little bit. Certainly if we are in our current environment with the way the Patent Office is examining and utilizing 101 rejections, if a claim is able to make it out of that, then hopefully by the time it gets to litigation, that issue is dealt with.
You know, on the front page of Investor Business Daily today, they had an article about this case. And I noted that they spun it in the direction of this is a great case for patent trolls. They even used that word in the article. Do you think that the Patent Office, because of political pressure from certain quarters, is going to take a very narrow view of patent eligibility in light of this decision as a way to avoid political pushback, if you will, for some of the patents that they've received the most criticism for, that they've been ridiculed for having issued? In other words, do you think examiners will go towards a default position of finding something abstract and then forcing the applicant to deal with it, as opposed to being more liberal in what they are going to find as being patent eligible?
I think they don't even have to go so far as to find something abstract. Under the new interim guidelines that issued today, the Patent Office is going to continue to use the machine or transformation test unless they have a specific reason to believe that a business method type claim is not abstract. And so they're essentially going to use it as the default. So from that perspective, I think the burden is now going to be on the applicants to show that it's not abstract. So the examining corps doesn't even have to go that extra step of determining whether or not a claim is abstract. As far as the political pressures go, they're subject to those already, and so I don't think their practice, given this, from a political perspective, is going to change because of this decision. I think it's going to be very similar to the practice that they've been having for the past couple of years.
Well, so now you have a very valuable invention from a commercial